Hi guys, welcome back to the channel. So if you have received a ban from Canada without IRCC giving you an opportunity to tell your part of the story in the form of a procedural fairness letter, this is probably the video that you need to watch till the end. My name is Niladri Mukherjee. I am a regulated Canadian immigration consultant and I practice in Mississauga, Ontario, Canada. So a lot of times that I see is that folks have been banned from Canada, but they did not receive the procedural fairness letter. This is not fair. This means that IRCC unfortunately may be breaching the process of natural justice. So the term itself is called the procedural fairness letter. So they have to maintain the fairness of the process, which is why they may think that you have misrepresented yourself, regardless of whether that is true or that is false. It is their opinion based on some observations, but by law they will have to give you a forum to explain your part of the story, which is why a PFL came into picture. So they will have to send you a PFL and then you have to respond. Now based on the response of the PFL, the officers are going to take a decision whether to ban you or not to ban you, right? But a lot of times that does not happen. They send you an inadmissibility letter banning you from entering Canada for 5 years anyways. What to do? Send a reconsideration request. But the reconsideration request is not like, well, please forgive me, I made a mistake, please take out the ban and all those things. It has to be a legal reconsideration request backed by facts, backed by documentary evidences, backed by all the other factors that would make the case strong. There is no such hard and fast rule that you have to provide this, you have to provide that. It will be a comprehensive kind of a reconsideration request. From my experience, I could tell you it is sometimes about 10 to 15 pager, and if it is being done, if it is being made, presented correctly, IRCC does reconsider the decision. Having said that, reconsideration of the decision does not mean giving you a visa. Reconsideration of the decision very well means they are willing to reconsider the inadmissibility or the ban that is being put forward on you, which is, I think, is a great thing, because if you are being banned from entering Canada for 5 years, this does not really mean that once the 5-year period expires, you can apply for a visa, but the possibility of getting that visa will be very, very insignificant, will be very, very low, because the track record of yours is not excellent in the books of the government of Canada. So if you're falling into those kind of circumstances, please come for a consultation. I do work with a lot of similar cases, and sometimes I do see that people have been traumatized with these kind of decisions. Do not need to be. If you have not received a fair chance to tell your part of the story, consider this as a chance, and we'll be more than happy to listen to your case, to go through your documents, to suggest the exactly appropriate next course of action. I hope this helps. If you need me to consult you, come for a consultation. Book through the website novonation.ca. We'll be more than happy to have a discussion. Hope this helps, guys. See you guys in the next one. Bye now.